right, Your Honor, first of all, I'm going to tender, as with a proper business record certification, State's Exhibit 523, regarding records for phone number from AT&T, regarding number 205-792-6806. I've shown the certification and the disc to Defense Counsel. So I would tender it at this time.
I'm sorry, Chuck, one more time, phone number on that one.
6806, 205-792-6806.
There's no objection to that.
It's amended.
Pursuant to business record certification as well, in the same manner, on State's Exhibit 524, cell phone record from AT&T pertaining to number 205-792-5128, which would be Leanna Harris's phone.
No objection to that.
And finally, State's Exhibit 525, which is, well, actually, these will be, I'll tender these. They've already been tendered. I'd ask they be admitted. And then I'm going to show Detective Stoddard what's been marked for identification purposes as State's Exhibit 525. Detective Stoddard, are those a physical printout taken from State's Exhibit 523, the phone records pertaining to the defendant's personal cell phone from June 15th up through June 18th?
That's correct.
Your Honor, I would tender State's Exhibit 525 at this time.
Just real briefly, if I may, Judge, the printout is only three days or 4 days?
Printout is from 6/15 through 6/19.
Okay, that's just a portion of what's contained on this number 523, Exhibit 523?
I would have to look at that, I believe so.
Your Honor, I believe these are the only numbers, the only dates that were requested for these records, so it should be it in its entirety.
Yeah, that's correct. Correct. The court order is request 6/15 through 6/19, so that should be the total order.
So what is printed out on 525 is everything that is on the disc for 523?
I didn't print it. I can't say it's everything.
And I would object.
Your Honor, it's on disk, it's in evidence. He's got it. He can print out anything that's not on there that he wants to introduce. I'm printing out the defendant's phone records.
I'm allowed it.
Thank you. Okay, Detective Stoddard, just in relation to, I guess, the death of Cooper Harris, did you pull phone records for the defendant and Ms. Harris to see what was, any phone calls made at the scene and things like that?
I did.
Okay, and were you given statements regarding what times phone calls were made, or there's still things that you needed to follow up on as well?
I did.
Okay, looking back at the phone records for Mr. Harris, the 6806 number on the 18th, did he have any phone calls until that afternoon? I'm thinking maybe starting on page 2 of the actual
First
printout.
phone call on 6/18 is going to be, this is UTC, so it says 12:41 a.m. And then a little bit later on, 1:41, that's mobile use, never mind, we pull over here.
Let's see if I can point you in the right direction here. I know those are convoluted. All right, looking at page 2 of the phone records, it's first phone call there at 3:49.
Yes.
Okay.
First phone call is going to be at 3:49 p.m.
Okay, now these calls, are there things on there that are reflected that appear to be some types of calls to phones that did not actually go through?
That's correct.
Okay, and what are the, well, we'll talk about that in a minute. Did you also have the defendant's phone to look at his call logs and things of that nature to try to match up and see if these are correct and what times phone calls were made and from where?
We did.
Okay. When you talk to the defendant, first of all, when you recover text messages from his his phone, did he get a text message from his wife about 3:16?
Correct.
Or did he text her at 3:16, sorry?
3:16, he texted her,
Okay, and what did he text her?
"You're gonna get Cooper," or "my buddy," I'm sorry.
What did he say, when? Are you gonna get my buddy?
Yes.
Okay. Now, at this point, talking to him and looking at the chat logs and anything, was there any question that she was gonna be the one to pick Cooper up?
No.
Okay. Had the plans already been made about going to a movie?
Correct.
From what you could ascertain, was there any reason for him to ask what time or when she was gonna be picking him up?
No.
Okay. After that, that text message he sent her, did he get a call around 3:49?
Correct.
Okay, and who was the call from?
Leanna,
Okay, and what was her phone number?
205-792-5128.
Okay, and was that corroborated by the numbers and records that you also pulled from Leanna?
It was.
Okay, and did they play phone tag back and forth for a few times?
Yes.
Okay, did they actually speak at some point per the phone records?
Yes.
Okay, at what time was that?
3:54 p.m.
Okay, now was that actually an answered phone call, or was that another missed call, and from who to who?
Looks like it's from Ross to Leanna.
Okay,
It's a 26-second seizure time, mobile direct.
okay, so do you know if that was actually something that they had conversation, or was it later where they actually talked?
I believe they had the conversation then.
Looking on later, did they have another phone call between the two of them?
No.
Okay. Was there any phone call or conversation of anything longer than a minute between the two of them?
No.
Okay. I'm going to turn your attention to 4:04 p.m. Do you see any phone calls there?
4:04 p.m., there's a 8-second call,
Okay.
and it's from Ross Harris's or the defendant's phone to Leanna's phone.
Okay.
Last time, 1:40.
So there was a phone call for 1:40 at 4:04.
Yep.
And the defendant, did he tell you at some point he'd actually gotten in touch with Leanna and they had talked? Or do you remember if you got that from him or somebody else?
I believe we got that from here later on.
Okay. And so after that 1:40 conversation at 4:04 p.m., was there any phone call made from the defendant?
Yes.
Okay, and what time was that?
After that phone call, 4:25 p.m., from his phone number, the defendant's phone number, to the Home Depot direct number.
Okay. Was there any phone calls before that he made that he called first?
Yeah. He attempted to call Leanna, and that's going to be at 4:25 p.m., and it's going to be the defendant's phone, calling Leanna's phone.
So that
4:24.
4:24 p.m.?
4:24 p.m., he calls Leanna.
And after he attempts to call Leanna, did he get through, or can you tell if there was any length of time of conversation?
No, there's no length of time, it's zeros.
So after he calls Leanna and he doesn't, and in his interview, did he say that he actually hung up?
Yes.
Now, when he says that, does he actually say, what does he say about hanging up? Like, why does he hang up?
He wanted to call the daycare, Little Apron Academy. He wanted to make sure Leanna didn't leave.
Well, with calling that, did he say in the interview, though, that he had actually called somebody else first and then Leanna was the last one?
That's true.
Okay. Well, when in the line of phone calls did he say he called Leanna in his interview as opposed to the records, if you remember?
I thought I saw you call Leanna last.
Okay. And do you remember how he described why he hung up on Leanna in the interview?
No.
Okay. So, whereas in the interview he says he called Leanna or last, how is it reflected in the phone records?
He called Leanna out first at 4:24 p.m. and hung up. At 4:25, she calls him directly back. Once again, there's zero lapse time. It goes directly to voicemail, or it goes to a voicemail, Ross or the defendant's voicemail.
Now, after he hung up, or he tried to call her, tried to call Leanna, does he try to make other calls at 6:25, or 4:25, excuse me?
He does. He calls the Home Depot direct number for about 27 seconds on there. And then at 4:25 p.m., he makes another phone call to the Home Depot, and it's their direct number. This seizure lasted 5 minutes and 16 seconds.
All right. Now, looking at, those are the AT&T phone records. Looking at the defendant's call log, did you review that as well to see if he actually had a call that was reflected on his call log regarding the calling the Home Depot.
We
It
did.
lasted some time.
We did.
Okay.
Look at the UFED record, which is that record we keep throwing up from his cell phone. There was a 5-minute and 13-second phone call from his phone to the Home Depot direct phone number.
And is this Home Depot like the corporate main number that shows up on these two records?
Yes, the store support center.
And we heard earlier from an employee of Home Depot as well that talked about phone calls, that how they can track whether the phone calls are made to a specific room or something depending
That's
on
correct.
dialing an extension. Okay, based through that, did you figure out where it was that he had called to Home Depot for those phone calls at 4:25 p.m.?
We did ask for records from them. The call went in through the main switchboard. And then he dialed, or the number was dialed to go to Tyler Room 5 over at the Little Aprons Academy.
And how long did their record suggest? Did they give us seconds or was it just minutes?
They
estimation?
just round it, and it's a 6-minute conversation according to their records.
Now, have you attempted to try to figure out how this happened?
Yes.
Okay. First of all, did you call, what did you do as far as Little Apron Academy to figure out if it rings to that number and then if it has voicemail and things of that nature?
Soon thereafter, we get the records back. I did call Little Apron Academy from my phone at the office, and I was connected to a voicemail. And in a subsequent interview, was told that a voicemail was left that next day. Also,
Did that have anything to do with this case, or was it just a test run to see if the voicemail worked?
well, it's just a test trying to see if I dialed this in, where that phone call was going to go to, and how quickly the the voicemail would pick up.
Had Little Apron had any voicemails on 618 from the
No.
defendant? Okay.
No.
All right. Did you test out how long the call would take if you left a voicemail?
It was around 2 minutes.
Looking at this, as you got the phone record, you see this call, had it been described by law enforcement, what was it described as how the defendant appeared at the scene as to whether he was on the phone or talking to somebody?
Officers from the scene said that they believed he was talking to somebody on the phone.
Based on all of these things, were you able to determine who the only person in the Tyler Room 5 was during that time?
We did.
And who was that?
At the time, Michelle Gray, and we found that out through her own testimony and through watching video surveillance of the hallways and both of the doors leading into the Apron, or the Tyler Room 5.
Now, do you have any video of who picks up the phone or anything
Nope.
like that?
No video of who picks up the phone.
Okay. Given that had you already interviewed her once before?
Yes.
Given that she was the only one in there and you had no other explanation for this, did you interview her?
A second time, yes.
And did you press her for information to see if there was some other connection?
I did.
Okay. And what did she say?
She said she did not answer that phone. She said she was the only person in the room. The phone did not ring. No voicemail was left. But she did not pick up the phone.
And did you look in to see if there was any connection, any phone numbers between the defendant and her, anything like that?
We did.
And could you find any connection whatsoever?
None whatsoever.
So as it stands today, do you know what the explanation for that call is?
No, it's unanswered. We got 3 pieces of equipment telling us a phone call was made. Nobody will admit to answering the phone.
So given there's a bunch of possibilities, you just don't know what happened.
Agreed.
Now, talked about interviewing witnesses and things like that. Did you also do lots of, how do you obtain records from business organizations and things like that?
Business organizations, you send out a court order.
And doing that, when you do that, you have to get a judge to sign it and then they send you records that are certified?
That's correct.
After you spoke with witnesses, did you also do further things, take part in scans of the crime scenes and things like that, or witness some of those things that were going on in the investigation?
That's true.
Okay. Did you try to follow up with Leanna to speak with her again
Yes.
the day after and her family? Okay, and were you able to?
No.
Okay. And basically, were you told that they were not speaking to you?
Objection.
Okay, let me rephrase. what were you told about your?
Objection. That's what I'm saying.
So basically, it goes to his investigation and to explain his conduct, because in furthering his investigation, why he would not have followed up with other family members, things like that, to interview them following up 618. So I think that's going to be part of cross-examination. So it's to explain why he did not and was unable to.
It doesn't explain anything, it's just hearsay. Whatever he was told for the truth of it is just plain hearsay. That's, I'm objecting.
It can be received as it relates to his conduct only, and not for the truth asserted.
Regardless of whether it's truthful about whether people would speak to you or not, were you told whether people would speak to you or not?
Yes.
Who did you talk to and what were you told?
I called up to speak with Nana's mom. The phone was handed to the person who identified himself as Michael Bajans. He stated that no one in the family.
Objection, hearsay.
Same ruling, it's limited. Ladies and gentlemen of the jury, you can't receive this testimony for the purpose of proving the truth of what's being said. You can only receive it to explain the conduct of the officer in the investigation.
Thank you. And without going into other people's names or anything like this, what did Mr. Bajans tell you about whether they would be talking to you or not, the family?
He said he would not talk to us to get a hold of their attorney.
Okay. All right, detective, in this case, I know we've heard a lot about different devices and things like that that were gathered and ended up, you guys obtained search warrants for them, correct?
Correct.
Now, initially, I know back on June 18th and June 19th, you said this investigation was fluid and different people had different responsibilities. Who was in charge of going and getting search warrants and things of that nature?
Detective Murphy.
Okay. And during that time, were you taking part in getting search warrants or anything like that, or were you doing other duties?
I was not. It was Detective Murphy.
Now, the search warrants from that day and on, or as far as searching these devices, did you obtain search warrants and did you search these devices?
Search warrants were obtained and devices were searched.
Now, going to, first of all, talking about several different devices, was there a device, we've got a lot of them already tendered in evidence and we talked about, a device that was seized and searched that was learned to belong to Leanna Harris, a MacBook?
Yes.
And just from that MacBook, was there anything regarding the defendant that was relevant to the investigation, or was it other things, different things, just on her MacBook that y'all noted?
Nothing relevant to the defendant.
Okay. Did you find older photos of Cooper in the car seat and other writings of Leanna's?
Yes.
Well, there are also several other items that really didn't have anything on them, either nothing or nothing of evidentiary value, flash drives, CDRs, things like that.
Multiple items.
Okay. And did y'all in fact have a computer tower that really didn't even have a hard drive in it?
That's correct.
Okay. Now going to, did you guys actually seize and search an Apple MacBook Pro that was determined to belong to the defendant?
We did.
Okay. Now, I'm going to show you what has been previously marked or admitted as State's Exhibit 322. Ask you if you recognize this.
I do.
Okay, and how do you recognize that?
It's the IEF report, Apple MacBook. Looks like one that came from my case file. It is. Where is it? Yeah, Ross's Apple MacBook.
And is this the IEF report that you had in your custody regarding the extraction and report that was done on that particular device?
Yes.
Okay. Now, who initially was the main person responsible for reviewing the contents of that Apple MacBook, if you remember?
Detective Stoppager.
And when he looked through it, did he pass along anything, things of note to you and things like that?
He did.
And did you go back and look through it as well to verify and look through what was on the Apple MacBook Pro?
I did.
First of all, relevant to, I know there's been testimony about prostitution and things like that, defendants' actions outside of his marriage. was there anything on the Apple MacBook Pro relevant to searching for escort services or things like that?
Yes.
Okay, could you tell the jury what that was? Just in summary.
In summary, there's just multiple Craigslist personals, there's 800 some searches. Backpage, which is another personal site, or has personals. Multiple porn sites.
Let me ask you this, in addition to the personal stuff as far as websites and, well, more towards the Craigslist items and Backpage, through this investigation, did you find out that, did you know any email addresses that the defendant used?
Yes.
Okay. First, I'm going to show you. Showing defense counsel what a mark for identification purposes states Exhibit 601 and 602. Okay, Your Honor, at this time I would tender State's Exhibit 601, which is Google Business Record Certification with attached records for email address from Google or Gmail, which is Ross Harris 00. I would tender that at this time.
The foundation business record seems to be in order. The only objection would be the prior objections made to this entire category of evidence. Everything that we talked about previously, 404, 403, severance, character, all of the things we've already discussed and argued about, just as to continue the objection on this basis.
Admitted over objection.
And same thing for State 602, Judge, which is the same type of certification for a Google account, email, Bama, BAMA 30067.
Same objections.
same ruling.
All right. Detective, these records that you obtained based upon court orders, in this case, as well for email accounts belonging to the defendant?
That's correct.
Okay. Now, were you aware of which email address was the main one you were aware of first?
The first one was the 00.
Okay, rossharris00@gmail?
Yep.
Okay. In addition to that, looking through chats and things like that and messaging, did you discover another email that he used, I guess, less obviously or less frequently?
Yes.
And which one was that?
That's going to be the Bama 30067 email.
And when you look through those records, were there a number of emails and chats relevant to the same thing as far as personal ads, prostitution, and things of that nature?
That's correct.
Did you also uncover emails and, I guess, video sent via email to any of the people, in this case, of the other witnesses?
That's correct.
And did those include Janie Meadows and Jacqueline Robledo?
That is correct.
Now, also on this Apple MacBook, in addition to all those searches and anything, did the other officers or someone locate a search regarding the topic of prison?
Yes.
Okay, and just generally, what was the nature, what was the exact Google search that was done?
The exact Google search was what prison is really like.
Okay. And were you able to ascertain any particular date whatsoever?
No.
Okay, and when you did looked at he had searched what is prison really like, is it just something that you noted that it could be relevant, could not be relevant, something like that?
True.
Okay. When you found that, were you able to go to and use the links that were shown on there as far as how the Google search appeared, and then if he clicked on any particular article
Yes.
specific to that? Also, initially, when you were in a meeting with law enforcement, did you initially think that the search term was something different?
Yeah, during a work meeting, before the probable cause hearing, it was brought forward, someone brought forward that it was how to search or how to survive prison was an actual search created.
Was this the actual search once you look back at it?
I was unable to find that when I went back after, it was like recreating or going through everything, verifying everything. I was unable to recreate that. The only thing that comes up, it's the closest I can get is what prison is really like. And then the second search or the link that's clicked on is like an Ask Men article, prison life and how to survive in prison.
You show defense counsel what are marked for identification purposes as states exhibits 603 and 604. Detective, I'm going to show you what's been marked for identification purposes of States Exhibit 603 and 604. Do you recognize these?
I do.
Okay. Now, how do you recognize those?
It's a Google search.
Without going into the contents of it, first of all, sorry, I'm just going to lay some foundation first. What are those printouts of?
It's printouts of an actual Google search and the link that is attached to it.
Okay. Now, when you went back into the Apple, the MacBook, where the Google search, or the link to the Google search he had done, what is prison really like, when you put that in and you click on that link going to the internet, is that first page what comes up?
Correct.
And is that as of today? Or, well, not today, within the last few days?
Last few days.
Okay. Do you remember if you actually went back and saw that exact date or those exact links back when you found the search terms?
I can't say that they're all here. The last one on the bottom, just to say it, but how to survive in federal prison was on there. And that was one of the first things we thought, is someone had actually gone to the search and then saw at the bottom how to survive in federal prison.
But as that is that just an example of what comes up when that Google search?
Yes.
Okay, now looking at the other exhibit, is that an actual exact link to a link included on his computer that he had viewed?
Yes.
Okay, and was that the same, would it have been the same link that he viewed back in, or whenever it was that he viewed that on his computer?
We believe so.
Okay, and was that also, is that just the most recent, I guess, was it printed off recently? It's been
Yes.
looked at recently?
It was.
And does it have a date of when the article was written by chance?
I have not seen one.
Okay. Your Honor, I would tender States Exhibits, I think it's 602 and 603 at this point.
I'd like to question if I could. If I could see those, please.
I'm sorry, 603, 604.
Well, three.
603 and 604,
I believe so, Judge, yes.
Brian, is that correct? That's correct.
Oh,
All right, so what you've identified as 603, this is a page of, appears to be a page of results from a Google search, what is prison really like, is that correct?
that is correct.
All right. When was this Google search done with those particular search terms?
You can't tell. Now, this one right here, I think it's printed off, was done within the last week or two to document this.
Last couple of days or so?
Well, I would say last week or so.
All right, so you certainly don't have any idea if these were the same results that would have shown up in this order or at all for those same search terms a year ago, 2 years ago, 3 years ago. You don't know.
The only one I do know about is all the way at the bottom, is how to survive federal prison.
Okay?
And that was the closest I was able to get to it. But if you go to the next line down, when you're looking on the computer, it's when that next one, the next article sitting there, that prison life, it's highlighted. ASMED, prison life, is on the computer.
Okay. So the other ones you don't recognize?
No, sir.
Number 1, 2, 3, 4, 5, 6, 7, 8, 9. The first 9 you don't recognize?
No, sir.
And then the next exhibit, which is identified as 604, appears to be some sort of article. Do you know with any certainty when this article was written?
No, I do not.
Okay. And more importantly, do you know if this article appears in the exact form, unamended in any way from when it allegedly was accessed by Ross?
No, I can't say that.
So somebody could have gone back in and done a complete rewrite for all you know?
Speculation, sir, I don't know.
Well, it's possible, right?
It's possible it's the same.
Okay. Possible, no?
Very true. But it is possible that that's the same exact article that was seen that day.
Bottom line is, this Google search, for these search terms, this document is something you created just a couple of days ago, and this article, you can't say with any certainty whatsoever when it was created, or if it was amended or altered in any way in the last year, 2 years, 3 years, whenever, correct?
I'll say correct.
no foundation for that whatsoever.
Judge, it goes to waive non-admissibility. This is an example of what comes up when you click on the links that the defendant had on his computer, just to show what it connects to.
Well, I'm gonna admit it, but you need to redact the items that cannot be identified.
Okay, will do, Judge.
And then the second piece is the article.
Yes, Judge, it was the article actually where the link is on his computer, and that is the link when you put it into the internet, that's what comes up.
Is that the link that he recognized?
Yes, I think so. That's the one that's actually on his computer. The link is on the forensic report of the Apple MacBook.
All right, I'll allow it over objection.
Thank you. Not going to publish State's Exhibit 603 at this time. The State's Exhibit 604. Just will you read to the jury the 5 topics it talks about as far as prison life on there?
Okay, this is prison life. 5 things men should know. Number 1, prisoners are segregated by sexual orientation, crime and race, among other factors. Number 2, to survive in prison, you have to join a gang.
I'm going to object to relevance also, Judge.
Judge, we've already argued the relevance as far as going to state of mind and things of that nature previously.
I understand that, but the problem is there's no date on that. We don't, I mean, there's no date associated with it, so I don't think that could be any relevance.
And then allowed.
Thank you. You can continue.
Thank you. Number 3, you can get anything you want in prison if it's small enough. Number 4, prisoners receive better medical treatment than you. Number 5, you probably won't get raped in prison.
Now, Detective, this was on his Apple MacBook computer, correct?
That's correct.
Now, those terms, we had them in there, it was noted. In all fairness, you can't say when, if he did that search or anything, correct?
No, I cannot.
Okay. But it was something that you guys wanted to note in your investigation.
It's something that came up, correct.
Okay, I'm going to turn your attention to the defendant's, are you familiar with his, the Lenovo laptop that he used for work?
Yes, sir.
And did you review that, along with several other items in the case? Did you review the Internet Evidence Finder report in that case?
I did.
And was this his main work computer?
It was.
Okay, did you come across a lot of Home Depot stuff on it?
That's correct.
Were there also some non-work related searches and things like that?
That's correct.
Are you familiar with the website, now familiar with the website Reddit?
Yes.
Okay, could you tell the jury what the website Reddit is?
Reddit's a social site, a social media, I won't say social media site, but a social site where people can post articles on and comment on those articles.
And is it a place where you can go and look for certain topics and if you want to learn about things?
That's correct.
Right. And in this case, did you attempt to, well, let me ask you this. When articles are posted on Reddit, can people or users actually make comments and things like that?
That's true.
Okay, did you attempt, through this case, to get any records? Did you find the defendant had a username, and did you attempt to get any records of comments he may or may not have made?
We did.
Okay? I'm going to show defense counsel what a mark for identification purposes as. detective. Well, Your Honor, this time I would tender State's Exhibit 605, which is the business record certification for links, comments, and messages posted by Reddit.com user Roscoe, ROSCOEUA, as far as Reddit.
I think as the foundation, I think certification is probably fine, but to the extent there's anything that's 404, 403, character, anything of that nature, we would object.
Okay, they've vetted over that objection.
And Detective, are these the records that you obtained from Reddit?
Correct.
And I know on these certifications, there was a couple, they're updated, there's a mark certification. Did you actually obtain these much earlier, back in 2014?
Yes.
Okay, these are just new certifications for, I guess, legalities of introducing it into evidence.
I believe so.
And from those discs, I'm going to show you State's Exhibit 606, did they provide in these records some comments that the defendant had made to certain articles and things like that?
That's correct.
Okay, and did you actually confirm by going to Reddit and looking, have you seen a comment on an article he made about a fight between some bikers and things like that?
Yes.
I'm going to turn your attention to June 14th, 2014. Looking at the comment right there, starting halfway down. If you made a comment about anything regarding witnesses that have seen and things like that.
The only reason I hold true to the bikers' actions,
Objection, it's not in evidence.
Oh, I'm sorry, Your Honor, I would let me ask you that. Is that comment taken from the records of the defendant's comments from Reddit?
yes,
Okay, so that would be his username and a comment that he would have made from that username from Reddit.
correct.
Okay. Now, I would tender the State's exhibits. I think 606. Yes, 606.
Yes, same objection, and I would add relevance.
Okay, the same ruling
And
relevance, your argument.
oh, Your Honor, this is talking about knowledge of the importance of having witnesses at a crime scene to corroborate your story.
Allowed.
Okay. Go ahead, Detective.
The only reason I hold true to the bikers' actions is the number of witnesses that stayed around to corroborate the story to the police.
And that was 2 weeks before Cooper's death.
Correct. 6/4, 2014, I'm sorry.
All right. Now, I'm going to turn your attention, I believe there's been some discussion, some introduction of the defendant typing in a link or typing in a website from Reddit as well called Child Free.
Correct.
Okay. Now, in the midst of your investigation, did one of your detectives or investigators come across an accessing of a website or a subreddit called Child Free back in April of 2014?
That's correct.
Okay. And obviously, since this was a homicide investigation, was this something of note?
Yes, at the time, yes.
Okay. Did you follow up on it as well?
We did.
Okay. Now, the records as far as this, first of all, just generally, what was when you go to the first page, what was the description back then of what the website was about?
Back then, it's just not adding more children, it's advocating not adding more children to the biomass.
Now, just kind of as you've done with as law enforcement did with a lot of things in this case, did you go further and look at other things as far as trying to investigate this?
We did.
Okay. Now, first of all, and Detective Yeager talked about this, was this something where he'd done, just clicked on a link, he had Googled it, or is it something he specifically typed in to the computer?
It was typed into the computer.
Okay. And looking back, once you obtained the...
I'm gonna, never mind, okay.
Okay. And looking back, when you obtained the Google email records and things like that, did you also obtain, I guess, thousands of chats and things like that between the defendant and numerous other people?
That's correct.
Okay. And since that time, having gone through them all, did you learn that it was suggested or brought up the topic of it by his friend Alex Hall?
That is true.
And going to the Internet Evidence Finder when the Child Free was actually typed in and he went to that, I believe we heard testimony that he initially clicked on went to the website, typed it in, went to the website, then went to an article.
Correct.
And then in the chats around, I think 2:05 p.m., he responded to the chat's grossness.
True.
Now, looking at the although it was just on this day, did he actually continue to read a couple of articles on the website after he said grossness?
He did.
Okay, and just to be clear, were these articles anything where, did he ever say, you know what, I'm joining this website or anything like that?
No.
Just for clarification, what were the names of the two articles of the descriptions that he read after he had said grossness?
Bingo by a felon and dating impossible.
And what were the nature of those articles?
Bingo by a felon is just talking about letting a felon in her family or knows her family about a kid, giving a kid to them, and dating impossible, I don't recall.
And after that, did you find any other connection? Did you basically try to research it and things like that? Did you find anything else specific to this website pertinent to the case?
No.
Now I'm going to turn your attention to some excuse me, web searches done in the days leading up to, or the week leading up to Cooper's death, about a vacation. From looking through the defendant's texts and things like that, were you able to locate discussions between him, his half-brother or brother-in-law, half-brother, his wife, and then his half-brother's wife as well,
Yes.
about a possible cruise?
That's correct.
And initially, was the defendant the one who talked about wanting to go on a cruise?
Yes.
As far as the Lenovo, on June 9th, did he Google anything particular to a vacation or a cruise?
6-9, I believe, was the group text when they were talking about it.
Okay. And were there any Googles about children cruising free or anything on that day? Some initial Googles?
I don't recall.
Okay. But if they were there, they would be on the disk?
Yes, they would.
Okay. Now I'm going to turn your attention to, and we'll get in more detail on this, the iPhone 5 that was recovered from the defendant. Were you able to recover text messages between the defendant and other parties?
That's correct.
Okay. The June 9th texts, as it were those relevant to trying to plan a cruise?
That's true.
Did you uncover any texts between Amy Bajents and the defendant?
Yes, I did.
Joint Defense Counsel, what's been marked for identification purposes, and states Exhibit 607. Okay, Detective, showing you State's Exhibit 607. You recognize State 607?
I did.
How do you recognize it?
Coming from the iPhone 5 extraction report.
And is that a report or a printout of the text conversations between Amy Bajents and the defendant, including June 17th as well?
That's true.
Okay, Your Honor, I tender State 607 at this time.
It's admitted.
Okay. Now, we talked about the fact that they discussed via text messages vacation June 9th. Had you seen anything in the Lenovo or any other place up until that point on the 17th, with the defendant Googling or doing anything, trying to check out or making plans for a cruise?
No.
Okay. What time, does he get a text from Amy Bajents on the 17th of June asking about this cruise?
He does.
Okay. What time is that and what is the text message?
On 6/17/2014 at 10:19:44 a.m., Amy Bajents texts him, "Did you talk to a travel agent about a cruise?"
Okay. Now, does he actually respond to that text?
He does.
And
At
what time does he respond?
3:16:18 p.m.
And when he responds, what does he respond?
Yes, I'm waiting to hear back.
We can set that down for a second. When you went back and looked at the defendant's emails from his main email account, did you find emails between him and a travel agent?
I did.
Okay. Showing defense counsel with a mark for identification purposes, states exhibit 608. All right, detective's going to show you what's been marked as states exhibit 608. Ask you to recognize this.
I do.
How do you recognize that?
It's an email printed off from Ross Harris, 00gmail@gmail.com.
Okay, and did he send an email to a travel agent?
He did.
Okay, and what is the time of that email?
6/17/2014 at 3:18 p.m.
So that email was not sent until after he got the text message from Amy Bajents and after he said he'd already contacted the travel agent?
That's true.
Okay, and is this the first email that you got about any type of travel?
That's true.
So after he said he had, but he hadn't?
Yes.
Okay. Your Honor, I tender states exhibit 608.
In evidence.
And Detective, will you go ahead and read for the jury what that email says?
All right, 608, subject cruise from Ross Harris, rossharris00@gmail.com. The date is 6/17/2014 at 3:18 p.m. and it's to Heather Coyle, Heather_Coyle76@yahoo.com. Heather, my family's looking to go on a cruise around mid-October. When I say family, I mean 9 people. That includes Leanna, Cooper, and I, as well as my brother, his wife, and his 6 kids. Cooper is the only toddler, but I was hoping you could put a few things together to see what we're all looking at. Any ideas? And it's signed Ross Harris, and his phone number 205-792-6806.
And so he hadn't done anything up to that point, but then he sends this email right after getting.
Objection. That's leading.
Okay. When does he send it? Before or after he gets the email from Amy Bajents?
After the text from Amy.
Okay. And was it before or after the text that he said responding that he'd already done something?
After.
Okay. I'm going to show defense counsel mark for identification purposes at states exhibit 609, 610, 611.
Once you've, if you've got them, if you've been, so this is what we're looking at.
Okay, Judge, and these have all been provided, they know exactly what they are.
Just a gentle reminder, Tom.
Thank you.
Just a very gentle reminder, Tom.
Thank you.
Which I think the message ought to be clear.
Yes.
I don't object.
Admitted?
All right, Detective, showing you what's been marked as state's exhibits. First of all, 609, 610, 611. Having provided these to the defense in discovery, now you're looking at them. Do you recognize those documents?
I do.
And how do you recognize them?
These are emails that actually came from Ross Harris's 00 Gmail account.
Okay. And are those emails also emails that he received from Heather Coyle back and forth in that discussion about the vacation?
True.
Okay, and those exact copies from the records of the defendant's main email account, the Ross Harris 00.
Yes.
Your Honor, I have tender states exhibits 609, 10, and 11.
I think there were,
Yeah.
All right. So, Detective, I'm going to ask you to look first at 609 and then 610. Would you just, as far as 609, just summarize the response from the travel agent to the defendant in this case about plans?
Quick summary from Heather to Ross Harris 00. She asked just a few questions, help me get started knowing you better, what you guys are really looking for, wanting a 7-day cruise, 5-day cruise, budget's the main factor. She talks about cost, approximate price per person, just questions concerning what they're looking for in a cruise, approximate ages of the other kids, what port they want to sail out of. I assume it'll just be you, Leanne, and Cooper in your cabin, or will some of your brother's kids, so. Mostly just looking for information about what they were looking for in their cruise.
Okay. And so she asked, in their cabin, is it just going to be defendant, Cooper, and Leanne?
That's true.
Okay. And the defendant, when he responds, would you please read to the jury that email, how he responds regarding costs and who will be in his cabin?
And this comes in on the date 6/17, 6/14 at 6:05
Thank you, yes.
p.m. Probably 5 days to keep our budget down. Location is flexible, but probably more Bahamas, Caribbean. Port Canaveral might be a bit far, but not out of the question. Maybe New Orleans or Charleston. Here's everybody's age, and he gives the ages. A couple boys and girls. I think I prematurely said 11 because my parents might come. And yes, our cabin would just be us. No per head budget yet.
And does he talk earlier about trying to keep costs down?
Yeah, probably 5 days to keep our budget down.
Now, after that, just going to the iPhone 5, when you look at web search history, was there a web search regarding passports at around 12:40 a.m.?
Yes.
Okay. And what was that in regard to? What was the search for?
The search on the phone was for passport kid prices. No application, anything like that. It was just kid prices for passports.
Okay. Was there any search about where to go get an application, how to get an application, or was it just trying to see how much it cost?
Just the cost.
And that was 12:40 on the early morning hours of June 18th.
Of 18th, yes.
Right before that and right after that, in the midst of all that, was the defendant at the same time, and we'll talk a little bit further about this later, also engaging in online communications with a ton of other people, other women and things like that?
Yes, he was.
Okay. Going to the next morning, looking at State's Exhibit 611, did the travel agent actually send an email back at 9:35?
She did.
Tell the jury a little bit about what she emailed and the different pricing options and things like that.
She starts off, Carnival's the only cruise line that lives out of the closer ports. Next closest port would be Port Canaveral. And then she kind of goes through some of the price options. 5-day Bahamas cruise, it's on the ship Carnival Fantasy and where it departs from in October. And she gives the prices. It's from $1,085 from 2 people to 5 people in the cabin to $1,843.
And how much is that one for 3 people in the cabin?
3 people in the cabin, it's $1,338.13.
Okay.
And then the second one, it's another 5 days. This is on the ship Carnival Fascination. once again, in October. And Ocean View cabin, for 2 people in the cabin, it's $740, 3 people is $980, up to 5 is $1,460 total. You can also do a balcony cabin in it. Then she does a 5-day Western Caribbean cruise. That's Carnival Elation.
Now, Carnival Elation, is that just a type of cruise ship, or is a name of a cruise ship?
Yes.
Okay.
And so the Ocean View cabin for 3 people is $1,006, up to 5 people. And it also includes a grand suite, and the grand suite's $29 for 5 people is $2,900.
So the Grand Suite is actually for 5 people,
Correct.
and it's over twice as much as any of the other cabins.
Correct.
Okay. So did that seem to fit any of the search criteria for what the defendant was seeking out?
The grand suite, no.
Now, what time was that email sent?
This email is sent from Heather to Ross Harris. That's the Ross Harris 00, 6/18/2014 at 9:35 a.m.
9:35 a.m. So, minutes after the defendant would have walked in the building.
Correct.
Okay. Based on his Google searches, were you able to corroborate, or is there evidence that he actually would have gotten that email based on a Google search he did?
Yes.
Okay. At 9:47 a.m., about 12 minutes after that email was sent, did he do a Google search?
Yes.
Okay. And about how long was he doing this Google search?
Not very long.
Okay. Like a matter of seconds?
Yes.
Okay. What was the Google search for?
For the grand suite on the Carnival Elation.
Okay. And when you go to this page, what does it look like? Is it just
That's
photographs?
photographs of what the suites look like,
Okay.
the rooms look like.
Okay. And was this the one that was for 5 people and was like almost $3,000?
Yes.
That one in any way seemed to fit what he was asking for as far as having 3 people and being cost effective.
No.
Objection, culpable speculation.
Your Honor, it's based on what he's already read and during this investigation, what it turned up.
Always sustain the objection, you can certainly argue it.
Okay, thank you. So, he Googles that. Did he Google any of the other options, or were there any Google searches for these different types of cruises, these different types of views, options, boats, anything like that?
None that I could find.
Okay, just the Grand Suite.
Just the grand suite, Carnival Elation.
Now, did he ever Google what's the best cabin for a child?
Not that I found.
Now, that email, looking at his email records, that day or at any point, like immediately after it, or any time, did he ever forward that email to family members,
I don't believe so.
to his wife,
I don't believe so.
to his brother?
Not that I found.
Did he ever follow up on it whatsoever?
There's no evidence that was followed up on whatsoever.
In addition to this, were there searches from June 17th about other types of, and other dates in late June about other vacation spots?
Yes.
Okay, what types of vacation spots?
Like Sandals, Bahamas, more exclusive type of resorts.
Were these resorts that did not allow children?
That is correct.
Okay. And these were all kind of that same time period in June leading up to the 17th.
That is correct.
And we'll get into it in a second, but reviewing the text messages as well between the defendant and his wife, did they actually go on a vacation around Memorial Day of 2014?
They did.
And did they get in a conversation about whether Cooper was going to go or not?
They did.
Okay. Did Leanna want Cooper to go on the vacation?
She did.
Did the defendant want the child to go?
No.
Did they end up taking the child anyway?
They did.
Additionally, while the Lenovo's being examined and things like that, I believe in the interview, the defendant talked about particular things he had seen, either TV or on the internet or things like that, regarding deaths in hot cars, or how hot it gets in a car on a hot day.
Correct.
Do you remember him talking about that?
I do.
And what did he say specifically about a veterinarian and something that he had viewed on the internet?
Specifically,
Detective, did you take notes of the conversation, or are you trying to be accurate about it?
I took, no, I'm just trying, you specifically, I
Yes,
want to
sir.
make sure we
That's-
get this.
I just want to make sure the jury knew what you're doing up there.
I'm sorry. I'm looking through the transcript to find the exact spot since we weren't specific, so.
And in the interview, did he talk about learning from the internet about how hot it gets in a parked car? I'm not, if I'd have said he did do that, it would be suggested. That's not suggested.
It's at page 249.
Okay, specifically, and this is from the defendant. And then just recently, there was a vet on the internet who, he said, even if you've got your windows rolled down, and regardless, I'm going to show you how hot it can get in a car. You think you could just leave your pets in the car, roll your windows down. You can't do that. And I watched that, and I'm like, that would be terrible. If my son was in the car, I would hate that.
So he talked about even if windows are rolled down, how it can still,
Objection, leading.
okay. Did it talk about, and what did he say about the effect of rolling window down and things like that with leaving a living being in a parked car?
Asked and answered.
Go ahead.
It says how can I get in the car? You can leave your pets in the car, roll your windows down, and you can't do that.
Okay. And did he specifically tie his son into thinking about this video?
He did.
Said did he? I didn't say he did, didn't he?
Go ahead.
Okay, you can answer.
Right. That would be terrible if my son was in the car. I would hate that.
All right, I'm going to show you, well, let me ask you this. When the Lenovo, you looked through it, did you actually find a video on the Lenovo, the link to the video?
We did.
Regarding, that he had seen regarding this veterinarian?
We did.
Okay, and did you immediately, after having looked at that link, view the video?
We did.
Okay, and what player or what type of website does it come up through?
When you click on the link, that's in the thing goes up on YouTube.
And later, with help from other forensic specialists, did you learn the path in which he would have gone to where would he have initially seen the link to go look for it and then click on it to go to YouTube to view it?
It would have been on Reddit.
Now, during this time, did it say how many times he had accessed the video?
It said it was accessed twice.
Now, do you know if that was actually 2 full viewings or something maybe he had refreshed it and not watched? Do you have any idea what it meant?
I have no idea. It just says twice.
But in the defendant's
It was accessed
interview,
twice.
he admitted having watched it.
Yes.
Showing defense counsel remark for identification purposes of state exhibit 612.
I don't object.
Admitted.
Detective showing you states exhibit 612, which has already been admitted. Do you recognize this?
I do.
And how do you recognize it?
This video I watched is Start the War, parked car video. It's a video from YouTube. It appears to be the video from YouTube that was accessed by his computer.
Okay. And you reviewed it as well based on the defendant's description of he would hated his son to have to go through that and the descriptions of how that video
That's
is.
not what the testimony was, Judge. I'm going to object to the way he's phrasing the question.
Rephrase the question.
Okay. Is it based upon, is this the same video that he talked about where he spoke about he would hate for that to happen to his son?
I believe so.
Okay. And based upon the defendant's description, does it fit the same description that he gave you as far as what is on that video?
Yes.
Okay. Your Honor, now that's been admitted, permission to publish.
How long is it?
About 5 minutes.
Okay.
maybe one of those times where it shuts down from watching all those other Home Depot videos.
Has that taken you very long in the past to rectify?
Not recently.
Just now?
Yes, yes, sir. I'm trying to open it in a different player, maybe that'll make sense.
Mr. Boyd,
Yes.
Ms. Galloway says there's one other one we do control alt delete, appears not to be responding as well.
Trying to make sure the sound is up. Telling you. Hi, I'm Dr. Ernie Ward. You know how veterinarians are always telling you never leave your pet in a parked car? It gets really hot. This is a typical summer's day. So I thought I would put myself in a parked car and let's see just how hot it gets. Come on. Okay, so I'm your pet and I'm now in the car. I've got all 4 windows cracked down about 1 inch. So let's start a timer and let's see exactly how hot it gets in here. The thermometer is reading at right about 94 degrees, 95 degrees. So it's pretty hot in here, but we're just getting started. So let's just kind of sit back and see how it feels in here. Okay, I'm at 5 minutes in. It is unbelievably hot in here. We're nearing 100 degrees already, and I can tell you that it is stifling in here. Even with all 4 windows cracked, there is no breeze at all. It is entirely still in here. It's oppressive. I mean, that's the best word for it. And 10 minutes in, I'll tell you, it is almost unbearable. At this point, the temperature is about 106 degrees. So, I mean, it's just getting to the point now where I can barely stand it. There's a breeze outside, and it's very frustrating because I can actually see the trees, the wind blowing, and yet even with all 4 windows cracked, between 1.5 inches and 2 inches, there's absolutely no breeze in this car. So if I were a little dog left out here, maybe I'm barking, I'm very nervous, I can only imagine what the core body temperature must be at this point. As I mentioned, it's 106 in here at 10 minutes in, and I'm beginning to wonder if this was a very bad idea indeed. Okay, I'm at 15 minutes now, and it's about 110 in my car. At this point, I would imagine if I were a small dog or a dog that is older, I'm going to be in serious trouble. It's been 20 minutes now at this point, and it is hovering right around 110, 112. It's kind of going back and forth here, depending on when we look at it. But needless to say, it's incredibly hot. 25 minutes. It's now, oh gosh, what is it? 113 degrees. It's awful.
The only thought that's going through my head right now is I want out of the car. You know, it's just, everything in my body is saying, get out, get out, get out. I can just feel rivulets of sweat just careening down my body. I don't know if you can tell, but I mean, I'm fully drenched now. I have sweat just completely cascading down my face and nose, my lips, and I can do that. A dog can't. A dog can't perspire. I mean, the whole point of this exercise was really to see what it feels like. What would it feel like to a dog to be stuck in a car? You know, you're helpless, you have no control over what's happening, you don't understand what's happening, you just know that your body is getting so overheated that you can be in real danger. I mean, this kills, and it's a lousy way to die. Okay, made it, 30 minutes. 30 minutes in a parked car with the windows cracked. The temperature right now is about 115, 116, really hot. What I really wanted to set out to do is see how it felt to be left in a parked car if I were a dog. And I know what's going on. I'm in control of the situation. What I can't imagine is how helpless and frightening it would be for a dog to be left in a car, not knowing when you're going to come, and slowly but surely having the energy and the life just burnt out of them by this heat. And you can make all the excuses you want. You can say it'll just be for a second. I'm going to leave the windows cracked. It's a breezy day. It's not that hot. But those excuses are meaningless unless you have sat in that car during that same time. And I can tell you, this has been an eye-opening experience for me as a veterinarian. And it will certainly make me that much more adamant and passionate about telling people never, ever leave your pet in a parked car during warm weather.
Probably time for a break.